dignitaries on and off the dais, my brothers and sisters on the bench and in the profession, ladies and gentlemen. It's a great privilege to be here. It has been just not even a year that I ceased to be a lawyer, but it brings immense joy to be amongst lawyers. I know all of you are waiting for the sessions to unfold. We are way behind schedule, so I won't take any more time, just a minute. When we actually speak in terms of environmental law and everything, I was amicus in number of matters touching environmental issues. And to my mind, if there is one statement on environment which actually brings out the essence of law, practice, approach, everything, it is the speech of that Indian chief which Justice Chinnappa Reddy quoted in Sachidanand Pandey. All of us must read that. Keep it close to your heart, and you have achieved everything. Thank you so much. Well, dignitaries on and off the dais, my friends. As Justice Mishra said, the topic is really vast. It's completely sort of unfathomable if we try to reach the contours of it. So let me deal with one minuscule portion from this entire topic. Access to justice. Friends, when Dr. Ambedkar, the architect of our constitution, he went on record to say that in his view, his opinion, the most sacred article of the Constitution was Article 32. He said that's the sheet anchor of the Constitution. And what is that article? Which guarantees to the citizen right to move the Supreme Court in case of violation of any fundamental right. That's, ladies and gentlemen, is the most sacrosanct and sacred statement to say regarding access of justice. Now there is one more article, and that's where our legal profession also gets spoken in the Constitution. Any person arrested has to be produced before a magistrate within 24 hours and has to be given an opportunity to have legal assistance of his choice. Unlike other professions, perhaps I think this is the only profession which is spoken of in the Part 3 of the Constitution. That's also access to justice. That within 24 hours, the limb of the judicature must be appraised of why, how, in what capacity, in what fashion, for what reason a person has been arrested. These are two fundamental features of so far as access is concerned. Now let's see it in a different light. As a youngster at the bar, I was junior to Mr. Sorabji. So I'll just narrate one case because that actually sort of unfolds beautiful theories. Let's see now. In one preventive detention matter, my senior was briefed. It was a matter from Bombay. And as junior working in the chamber, I got to be briefed along with him as assisting counsel. On the very first day, when the matter was actually to be taken in Supreme Court, About half a dozen counsel had come from Bombay to instruct Mr. Sorabji. So the entire Jingbang lot came, instructed, they were put up in a 5-star hotel. The first day the notice got issued in the matter. Next 2-3 occasions, the very same battery of lawyers would come attend the hearings, but unfortunately nothing substantial happened. The matter simply used to get adjourned. Went on for about, say, 4 or 5 occasions such as this. On the 6th occasion, the solicitor concerned sent me the brief, as usual, because earlier 5 occasions I had also appeared. But unlike the other earlier occasions, the docket simply said, Mr. Uday Umesh Lalit. I said, but with whom? Because as an assisting counsel, naturally you are supposed to be briefed with somebody else. The message came, no sir, you are going to appear. Very well, I did appear. And I just casually asked the client that, why is it so? On the earlier occasion, you had that big tamasha of 6 counsel coming from Bombay. And why now nobody else is turning up? His answer was, he gave in Gujarati, if I may just translate it. It was, कुएं पर पानी पीने के लिए आए थे सर, पर सारा पानी हाथ पैर धोने में ही खत्म हो गया. What it means is that we had come to the well to drink water, but unfortunately the entire water got wasted in just cleaning my hands, washing my hands and feet. And that's the apathy, that's the tragedy which actually visits upon most of the litigants today in every walk of life. Their resources are limited, their chances are limited, and those chances and resources get frittered away. So merely in theory saying that very well, create courts, create opportunities, create facilities, create infrastructure, create all kinds of opportunities, does that actually serve the purpose? The basic thing, and therefore when we actually speak so far as access to justice is concerned, there are 2 cues which are very, very important. One is quality of assistance which is given to a litigant. Every time whenever he needs it, it is the quality which actually matters, which means quality on both fronts. Coming from the presiding officer of a court, at the same time, the legal assistance which you are actually giving him. So one is, the first cue is quality. Second is quickness in the entire process. If we are delaying everything, as Justice Mishra said, delay would defeat everything. So therefore 2 cues, quality and second one, quickness in the entire matter. And we must forget and bury deep the other cue, that is queuing up in court. I have seen, and perhaps I think we in the legal fraternity are also responsible. Very innocent, citizens at times ask you that why is it that the matters keep clogging the court? Is that the answer, that you just have to increase the number of judges? You just have to increase the number of courts? Tribunalization? Is that the answer? In theory, you are all legal practitioners. In theory, half the litigants are interested in protracting the litigation. And if these are the instructions to the lawyers, I have received instructions at times from people, Saab, 2 saal chala do na. And that's the instructions which we as lawyers actually receive. And that's where we as lawyers have to actually sort of, that's the contribution which the society expects from you. All this is essentially just jargon. Access to justice, have many courts, tribunalization, etc. Unless and until there is a substantial change in our approach to the matter, in our approach to the entirety of the situation and the contextual nature of that matter as against the interest of the society, nothing is going to change. So therefore, I would appeal to all of you to remember these two cues and bury the other queuing up. And at the same time, I really learned from that experience which that client told me. Those words are actually ringing in head every time they stay there. And that's what we should not allow the thing to happen. We should not reduce the entirety of the process to that level. So therefore, if every one of us actually does his bit, that is, as and when the cases are called out, we do our matters without even asking for adjournment, without even asking for any accommodation, I think the problems would be solved. That's my humble suggestion to all of you. Thank you so much.